Let me begin with a simple question. What happens when a girl wants to attend school, but her own body becomes the reason she cannot? This was not a philosophical question before the Supreme Court, it was a constitutional one. In January 2026, the Supreme Court of India delivered a judgment that quietly but powerfully altered how we understand the right to life under Article 21. In Dr. Jaya Thakur versus Government of India, the court recognized something that had long been ignored in constitutional discourse, that menstrual health and hygiene are not optional welfare measures but fundamental rights. This case is not loud, it is not sensational, but it is deeply transformative. To understand why, we must return to where it all began. The case began as a public interest litigation under Article 32, the heart of constitutional remedies. The petitioner, Dr. Jaya Thakur, approached the Supreme Court with a concern that was neither abstract nor symbolic. It was painfully real. Across India, thousands of school-going girls were missing classes, not because they lacked intelligence, ambition, or willingness to learn, but because their schools lacked something far more basic: access to sanitary pads, a private functional toilet, water, safety, dignity. The petition did not speak of isolated failures, it spoke of systematic neglect, a pattern that repeated itself in urban slums, rural schools, and even private institutions. Menstruation, a natural biological process, had become an unspoken barrier to education. The court was presented with facts that revealed an uncomfortable truth. First, absence of menstrual products. In many schools, girls had no access to sanitary pads, no emergency support, no institutional system. When menstruation began during school hours, girls were left with one choice: to go home. Some never returned. Second, broken sanitation infrastructure. Many schools either had no separate toilets for girls, or had toilets without doors, water, or privacy, or had facilities so unhygienic they were unusable. For a menstruating girl, this meant fear of stains, of ridicule, of shame. Education became secondary to survival. Third, impact on education. The data revealed a pattern. Girls missed school every month. Learning gaps widened. Dropout rates increased during adolescence. The right to education existed, but access to it did not. Fourth, silence and stigma. Menstruation was not discussed, not in classrooms, not in policies, not in accountability frameworks. The silence itself became a form of discrimination. Faced with these facts, the Supreme Court asked questions that went to the core of constitutional morality. Can the state claim to protect the right to life while ignoring basic dignity? Can education be meaningful if attendance is impossible? Can equality exist when biological realities are ignored? At this heart, the case asked, does the Constitution see girls as full participants in public life? The petitioner argued that menstruation is not a choice. Disadvantage arising from it is not accidental, and exclusion resulting from it is not neutral. Dignity, privacy, bodily autonomy, these are not abstract ideals, they live in classrooms, toilets, and school corridors. The government, while pointing to existing scheme, acknowledged a critical reality. There was no uniform, enforceable, accountable framework. Policy existed, rights did not. Supreme Court responded with constitutional clarity. Article 21 is equals to right to life. The court reaffirmed that life means more than existence. It means living with dignity. And dignity cannot survive where shame, fear, and exclusions are institutionalized. Menstrual health, the court held, is inseparable from a dignified life. Article 21A is equals to right to education. Education, the court said, is a multiplier right. But a right that cannot be accessed is no right at all. If menstruation keeps girls out of classrooms, then the state has failed in its constitutional promise. Article 14 is equals to equality. Equality does not mean ignoring differences. It means responding to it. Failing to address menstrual needs is indirect discrimination, even if it's unintentional. The court's direction were practical, clear, and binding. Free sanitary pads in schools. Functional private toilets with water. Safe disposal mechanisms. Institutionalized menstrual hygiene management. Sanitization and awareness. This was not charity. This was constitutional compliance. This judgment matters because it changed the conversation. It told the state you cannot speak of development while ignoring dignity. It told schools education is incomplete without inclusion. And it told society biology must never become a barrier to equality. In Dr. Jaya Thakur versus Government of India, the Supreme Court did something quietly radical. It listened. It recognized the constitutional rights must reflect lived realities. and it affirmed a simple but powerful truth. No girl should have to choose between her education and her body. This is not a privilege, this is a fundamental right.